The Supreme Court in a 3-2 majority judgment has ruled that marriage is not a fundamental right and that gay marriage can be legalized only by an act of Parliament. While the Chief Justice headed 5-judge bench unequivocally spoke up for the rights of consenting adults to choose and cohabit with a partner of their choice, the top court exercised restraint and chose to let Parliament legislate on the issue of gay marriage. There was unanimity among the 5-judge bench to the effect that the Supreme Court cannot read into existing laws on the right to marry. However, the Chief Justice observed that marriage is not a static or an unchanging institution.
To imagine queer persons as existing only in urban and affluent spaces is to erase them, even as they exist in other parts of the country. It would also be a mistake to conflate the urban with the elite. This renders invisible large segments of the population who live in urban spaces but are poor or otherwise marginalized.
Justice Bhatt held that the state has indirectly discriminated against the queer community by not creating an institution. He said that the failure of the state to recognize queer relationships has had a disproportionate impact on LGBTQ community. However, Justice Bhatt in his judgment added that marriage cannot be elevated to the status of a fundamental right.
The Constitution does not expressly recognize a right to marry. While we agree that there is a right which we characterize as a right to a relationship, which is recognized in Navtej that the queer couples and other relationships of that kind can have a union.
When it came to the issue of adoption rights for queer couples, the court was more circumspect. While ruling against adoption as a queer couple, the court said while it did not believe that queer couples cannot be good parents, children may be deprived of legal benefits. Chief Justice Chandrachud had held that any bar on queer couples from adopting was violative of Article 15 of the Constitution, which prohibits discrimination against any citizen on the grounds of religion, race, caste, sex, place of birth, or any of them.
This is not to say that unmarried couples, whether queer or heterosexuals, are not capable or suitable to be adoptive parents. However, once the law permits, as it has done, adoption by both single individuals, the likelihood of their joining and cohabiting cannot be ruled out.
The Supreme Court may have passed the onus of legislating on same-sex marriage to Parliament. However, it did propel the centre to set up a committee headed by the Cabinet Secretary to look into some of the issues that same-sex couples face. The centre in the Supreme Court had argued against legalising gay marriage, so it remains to be seen what this committee will look into and when it will be set up. The ball is now literally in the centre's court. With Ashmit Kumar in New Delhi, this is Shireen Bhan.